Yeah. Okay, let's unpack one of the most intellectually satisfying yet morally murky corners of commercial law, the implied duty of good faith performance.
Hmm. We are diving into a crucial question that, it underlies every business relationship you'll ever enter. How much honesty, cooperation, and disclosure do you actually owe the person on the other side of the table? It is the ultimate tension point, isn't it? I mean, we all know business is competitive and the law encourages smart people to use their knowledge to gain an advantage. But where is the line?
Exactly. What happens when one party spots a massive, potentially catastrophic oversight in the contract by their partner and then deliberately exploits it for a multi-million-dollar unbargained for windfall?
That's the mission today.
We are going to strictly dissect that line between permissible exploitation of superior knowledge, what the courts call social product, and forbidden opportunistic sharp dealing that adds, nothing to the economy. We're going to show you the precise element by element analytical method that courts use.
And we will do that by drilling deep into the source material, specifically the implied covenant of good faith performance, which, the common law reads into every single contract. Our anchor case for this is the seminal Seventh Circuit decision, Market Street Associates v. Frey.
Ah, a classic. Featuring a huge corporate pension fund getting outmaneuvered by a much smaller, quick-thinking real estate partner.
Exactly.
Okay, let's establish the foundation first. Why does the law even bother reading a duty of good faith and fair dealing into a contract at all, particularly after both parties have already signed? I mean, we had our chance to negotiate, right? That timing distinction is everything. The general rule is robust. The common law of virtually every state reads a duty of good faith into contract performance. And the purpose of that?
Well, it's not to rewrite the deal. The purpose is to prevent one party from using a loophole or an unanticipated circumstance to basically steal the benefit of the bargain from the other. Judge Posner described it as the court taking a stab at approximating the terms the parties would have negotiated had they foreseen the circumstances. It's really a tool for reducing the total cost of performance.
I understand minimizing costs, but it sounds dangerously close to altruism. You mentioned the distinction from a fiduciary duty earlier. Why isn't this simply a duty to be totally upfront, a duty of candor?
Because it is absolutely not a fiduciary duty. This is crucial for you to remember. In a fiduciary relationship, like, say, a lawyer and client, the duty is one of utmost good faith. You have to put the other party's interests first.
Right.
In a commercial contract, the duty of good faith is so much narrower. You are absolutely not required to be an altruist or your brother's keeper. You don't have to spend money, take risks, or inform your partner of superior market knowledge you happen to have.
So if I don't owe my partner candor, and I can act purely out of self-interest, how is the line drawn? If I see a chance to make an extra $1 million, where does allowable self-interest end and forbidden bad faith begin?
The line is drawn precisely at the concept of opportunistic behavior. Good faith forbids you from taking deliberate advantage of an oversight by your contract partner concerning their rights under the contract. The key is the policy rationale behind this.
Okay, tell us more about that policy rationale, this idea of social product versus no social product.
Okay, so when you exploit superior knowledge, say you hire a geologist, you discover hidden oil on land you are contracting to buy, and then you close the deal without telling the seller that's permissible.
Why?
Because you invested time, money, ingenuity to gain that knowledge. That effort has social product. It encourages productive investment and, knowledge creation.
And exploiting an oversight.
That's totally different. Exploiting an oversight or opportunistic sharp dealing has no social product. It doesn't encourage investment. It just transfers wealth from one party to another purely through trickery.
Okay.
This kind of conduct only induces the other party to spend costly time and money on defensive measures, like hiring lawyers to read the contract 14 times, which is just wasteful. The court wants to kill the incentive for that waste.
That makes a lot of sense. It's the difference between profiting from your own hard work versus profiting from their clear mistake. And you emphasize that the timing is critical. Why is that duty maximized after the contract is signed?
Because before the contract is formed, both parties are adversarial. They expect wariness. The duty to disclose is low.
Right, you're on guard.
Exactly. But once the ink dries, you're supposed to be in a cooperative venture, a team working toward a common goal. In that cooperative stage, they lower their guard a bit. If you use that moment to spring a deliberate trap by staying silent, the law views that silence as far more deceptive.
Okay, this is where it gets really interesting. Let's apply this strict test to the facts of Market Street Associates v. Frey. We need to see how a party that was supposedly so sophisticated got caught in this trap.
Let's do it. We will use the mandated analytical structure to walk through this landmark decision.
Let's analyze Market Street Associates v. Frey. First, what are the legally dispositive facts? All right. The underlying transaction was a sale and leaseback from J.C. Penney to the General Electric Pension Trust, GEPT. Market Street Associates later took over the lease. The whole case, is in an obscure provision, paragraph 34. Tell us about that crucial paragraph, because that's the source of the whole legal disaster.
Paragraph 34 was a financing clause. It said that if the lessee, Market Street, requested financing from GEPT for improvements over $250,000, GEPT had to give reasonable consideration and negotiate in good faith.
Okay, that sounds normal enough.
But here's the hammer. If GEPT refused to negotiate, or if negotiations failed, Market Street gained an extraordinary right, the option to repurchase the entire property at a formula price. And at the time, that formula price was around $1 million, while the market value was over $3 million.
So GEPT's penalty for just saying no to a financing request was to lose the property at a huge loss. That's a massive trap. What was Market Street's conduct here?
So Market Street's general partner, a guy named Orenstein, requested $2 million in financing from GEPT. Crucially, in his letter, he never mentioned paragraph 34 or the repurchase penalty.
He just asked for the money.
Right. And GEPT's representative, Herb, he just rejected the request, citing GEPT's standard policy that they only fund projects over $7 million. Herb was, it seems, totally unaware of the deadly clause his refusal would trigger.
And that's where the alleged trickery comes in. What did Orenstein do next?
Orenstein responded with what the court later called the lulling letter. He wrote back, acknowledged GEPT's refusal, and said that Market Street would seek financing elsewhere.
Making it seem like the issue was closed.
Exactly.
Yeah.
1 month later, having successfully lured GEPT into forgetting the issue, Market Street dropped the Thunderbolt, formally exercising the paragraph 34 repurchase option. GEPT, of course, refused to sell, claiming bad faith.
And what was the core legal issue that the Seventh Circuit had to resolve? The issue was, did Market Street Associates breach the implied duty of good faith performance by intentionally failing to alert GEPT to the existence of that paragraph 34 repurchase option? And, was that opportunistic sharp dealing? What rule of law did the court apply? Please state the full black letter rule and break it down into the hard legal test the jury could actually use.
Okay, the rule is that the contractual duty of good faith forbids opportunistic behavior designed to take deliberate advantage of an oversight by a contracting partner during the performance stage. The court then refined this into a test with 3 essential elements.
What are they? First, deliberate or deceptive intent. Did the party specifically intend to trick the partner by preying on their probable ignorance? This is all about the actor's state of mind. Okay, intent. Second, opportunistic advantage taking. Did the conduct create an unbargained for windfall, the very definition of sharp dealing that lacked any social product? And third, post-contractual timing. Did this all happen during the cooperative performance stage where, as we said, silence is much more deceptive? That's a clear structure. Thank you. Now for the court's elemental analysis. Let's walk through this. How did the court apply that first element, deliberate deceptive intent, to Orenstein's actions?
Well, the district court, in its initial ruling, it inferred intent from the timeline. They basically said Orenstein had every reason to believe GEPT's representative, Herb, was oblivious to paragraph 34.
He was counting on them being a big, slow bureaucracy.
He was accused of betting on GEPT's sluggish and hidebound bureaucracy. And on top of that, the court saw that lulling letter as the smoking gun-strong evidence of a calculated scheme to deceive.
The court is basically saying the silence wasn't passive, it was strategic. I get it. Now, what about the second element? Opportunistic advantage taking. How did that huge price difference play into it?
The disparity was key. The court noted that if Market Street did intentionally exploit Herb's ignorance, it was the very definition of sharp dealing. This wasn't Market Street knowing the land was valuable. This was Market Street knowing that GEPT was about to accidentally breach its own contract and forfeit a $2 million property interest.
That's a different kind of knowledge.
It is. Exploiting this specific type of mistake, a mistake about the contract itself, is seen as inherently opportunistic because it serves no legitimate business purpose. It's just wealth shifting. Zero social product.
Finally, how did the court treat the third element, the post-contractual timing? I mean, why wasn't GEPT just expected to be diligent? They're a massive entity.
The court used this element to directly address that very question. Why protect a huge, arguably negligent corporation? The court stressed that the duty is maximized post-contractually. While GEPT was negligent, Market Street was alleged to have intentionally exploited that lapse years after the cooperative relationship began.
So the timing changes everything.
Completely. Had Market Street done this before the lease was signed, it might have been fine. But by waiting and using that lulling letter during the performance phase, Market Street abused the trust inherent in that relationship.
And after analyzing all these elements, finding strong evidence of intent, clear opportunism, and that heightened post-contractual duty, what was the court's final conclusion?
This is the crucial part. The Seventh Circuit reversed and remanded the summary judgment. They did not rule for GPT, they sent the case back for a trial.
Why? It seems pretty clear-cut.
Because while the evidence overwhelmingly supported the theory of bad faith, the crucial element of Orenstein's state of mind, whether he actually believed Erb was ignorant and was trying to trick him, that's a question of fact. It couldn't be resolved by a judge alone. A jury had to decide.
So was he just being sloppy, or was he being deliberately deceptive?
That was the multi-million-dollar question for the jury.
This is where it all crystallizes. The court is drawing a line between permissible gain from my own effort and impermissible gain from exploiting your error. Let's test this with a couple of visceral hypotheticals.
Excellent. This is the only way to make the distinction stick.
You contract to buy an antique desk for $500. You spent years studying furniture history and know, based on this specialized knowledge or investment, that the desk is a rare period piece worth $50,000. The seller has no idea. You say nothing. Have you breached the duty of good faith?
No breach. This is pre-contractual. You're in the negotiation phase. And more importantly, you're exploiting superior knowledge that you earned, which has social product. You are not required to be your seller's furniture appraiser. The law lets you profit from your diligence there. Okay. Scenario 2. You have a long-term supply contract. Your partner has to deliver 100 industrial solvents by October 1st or pay a $10,000 penalty. Just before delivery, your partner sends a communication about the address, but it has a simple typo. The street number is wrong. You know the delivery will fail if you stay silent. You deliberately choose to do nothing, letting the failure happen specifically so you can claim that penalty. Breach of good faith.
Yes, that is a clear breach. It fits the Market Street rule perfectly. You're deliberately exploiting your partner's mistake during the performance stage. You could have fixed it at zero cost to yourself, but you chose silence to reap an unbargained for reward. That's textbook opportunistic sharp dealing.
That zero-cost correction test seems to be a key diagnostic tool. If you can fix the problem for free but choose to stay silent to win a huge windfall, you've probably crossed the line.
Precisely. The focus is on the intent to exploit a known oversight in a relationship that demands some baseline cooperation.
To bring this powerful analysis together, especially for those who need to diagnose these issues quickly, let's synthesize this into a step-by-step diagnostic checklist.
Absolutely. This diagnostic framework applies the lessons of Market Street directly to any scenario you might encounter.
Give us the first step. First, the stage check. Is the conduct happening during contract formation pre-signing, low duty, or during contract performance post-signing, high duty? If it's performance, you proceed. The duty is way higher. Got it. If we're in the performance stage, what's the core question to ask next? Second, the motive check, the good faith line. You have to determine the source of the profit. Is the party exploiting superior knowledge they earned? That's permissible. Or are they taking deliberate advantage of a partner's mistake about their contractual rights? That's forbidden. Opportunistic sharp dealing. Superior knowledge adds value. Exploiting oversight just shifts wealth. And what evidence do we look for to prove that deceptive intent? Third, the conduct test. Look for deliberate deception. Did the party engage in strategic silence, a calculated omission? Or did they send a lulling letter designed to prevent the partner from protecting themselves? If the goal is to set a trap, you have a problem. And finally, if bad faith is proven, what happens to that ill-gotten gain? Fourth, the remedy. If bad faith is proven, the court's goal is to defeat that opportunistic windfall. They'll either imply a condition, saying the party had a duty to speak, or just enforce the contract as if the bad faith conduct never happened. Either way, the perpetrator doesn't get to capitalize on their deception. So what does this all mean for the business person? The critical takeaway here is that once you're in a contract, the law demands a baseline of cooperation. You can be self-interested, but the moment you can correct your partner's major mistake about their own rights at zero cost to yourself, and you choose to stay silent to engineer a massive windfall, you've likely crossed the line.
And what's so fascinating here is that even the General Electric Pension Trust, an entity with immense resources, was protected by this duty against its own gross negligence. It raises an important question, right? If the law is willing to shield even a massive, sophisticated corporation that missed a multi-million-dollar clause, what does that imply about the level of trust and cooperation required for any functional long-term business relationship to survive?
It means the law prioritizes productive collaboration over cynical wealth transfer.
That's exactly right.